Chair recognizes we will move to consideration of Resolution 502, and the Chair recognizes Lucian Dervan of Tennessee, member of the Board of Governors. Mr. Dervan, we have no salmon slips in opposition, therefore the rules of limited debate will apply. You have 5 minutes.
Thank you, Mr. Chair. My name is Lucian Dervan from the Tennessee delegation, and I'm here to speak on Resolution 502 regarding the 14 principles of plea bargaining. Madam Secretary, I move Resolution 502.
Second.
Thank you. Our criminal justice system is a system of pleas. As many of you know, 98% of federal convictions and 95% of state convictions come not from a trial, but from a plea of guilty. And while there are many benefits from having such a plea system, there are also many troubling elements of plea bargaining that must be addressed. For example, there are costs associated with having a vanishing trial. Things such as lack of oversight, inability of courts to interpret and weigh in on laws, and a lack of community involvement in the criminal justice system itself. In one example from Arizona, there were no criminal trials for a 2-year period of any kind in one particular county, and therefore no community involvement. We have seen plea practices also develop that create impermissibly coercive incentives that leave defendants no choice but to plea and prevent them from exercising their constitutional right to trial. These include the use of mandatory minimums and trial penalties for exercising that right, and even in some cases that we've found, the use of threats to indict family to coerce an individual to accept a plea offer and give up their right to trial. These types of coercive incentives lead even innocent defendants to plead guilty. In fact, 30% of the cases added to the National Exoneration Database in 2021 were false pleas of guilty by the innocent, not those convicted at trial. And in a 2023 report from that same organization, they revealed that in fact, 40% of their entire database currently are what they call no-crime exonerations. No-crime exonerations being exonerations where no crime ever occurred. It wasn't a wrong individual convicted. There was, in fact, no offense. And you may not be surprised to learn that almost half of those no-crime exonerations in the database are now false pleas of guilty by the innocents in the face of impermissibly coercive incentives. We have also seen the use of impermissible conditions in pleas, one example being from Tennessee, where female defendants were forced to accept sterilization in return for plea deals in child abuse cases. And we also know that the current plea system exacerbates racial inequality in the criminal justice system itself. And so in response to these issues, the criminal justice section convened a task force whose members represented all corners of the criminal justice system. Representatives from the prosecution and the defense, from the judiciary and from the academy, from advocacy organizations on all sides of the political spectrum, representatives also from the state and the federal systems. And those members looked at these issues and they spent almost 4 years crafting and then unanimously adopting the 14 principles that are now contained in Resolution 502. These 14 principles address the issues that I have raised and others, and create a path forward towards a more transparent, fair, and more just system of plea bargaining. It does this by encouraging an active docket of trials, by establishing principles to prevent coercive plea bargaining, and by encouraging more transparency and data collection related to plea bargaining. In closing, let me quote from one of the members of the task force who helped craft the principles, the director of the Office of Policy and Legislation at the U.S. Department of Justice. Quote, "Laying out principles for the plea process is important. More important, though, is creating a culture of a healthy adversarial system that does away with coercion. The adoption of principles by the ABA is an important step in creating that healthy culture," end quote. This resolution is supported by the criminal justice section, the section of civil rights and social justice, GP Solo and the Center for Human Rights. Please join us in supporting these 14 principles that serve as a guide for plea bargaining practices going forward. Thank you.
Thank you, Governor Dervan. Chair now recognizes Wayne McKenzie of New York from the Criminal Justice Section to speak in favor of the resolution. Mr. McKenzie, you have 2 minutes.
Thank you. Good morning, Madam President, Chair, and to my colleagues here in the House. When I last appeared before you, I had to share that I was not Steve Salzberg. And so this morning I have to add to that, I'm also no Neil Sonnet. But for less than the next 24 hours, who I am is the immediate past chair of the Criminal Justice Section, and someone who started their career in the Kings County, Brooklyn District Attorney's Office, and currently an executive and the chief of the Pathways to Public Safety Division of the New York County District Attorney's Office, and also a past national president of the National Black Prosecutors Association. And so it's in these capacities that I urge you to support this resolution. And I want to talk about just one of the principles. No one here would dispute, for example, that discovery is a pillar of the government's responsibility to prove the guilt of an accused beyond a reasonable doubt. You've just heard that 95% of state cases, 98% of federal prosecutions end with plea bargains. And so how is it that we cannot give an accused exactly the same considerations when we're talking about plea bargaining and allowing them a meaningful, voluntary, and knowing opportunity to enter a plea? But I'll give you probably the strongest argument. As a prosecutor who myself practiced open file discovery, what I saw was that it actually increased and encouraged plea bargains. But in 2 occasions, it provided the defense attorney with an opportunity to provide me with evidence that prevented me from convicting 2 innocent human beings. And so I urge you to please support this resolution. Thank you.
Thank you, Mr. McKenzie. Chair now recognizes Cynthia Orr of Texas. She waives. Chair recognizes Stephen Salzberg. He is waiving. Governor Dervan, you waive as well. Therefore, the question is on the adoption of Resolution 502. All those in favor, please say aye. Aye. Opposed, no. The ayes have it. Resolution 502 is adopted.